I'm Bill Cash. I've been with the EEOC since March of 1992. I started off as an attorney with the EEOC, working out of the Memphis office, and kind of most of what I've done with the EEOC is help with investigations of employment discrimination claims and litigate employment discrimination claims. Most of my litigation experience over the years was in Tennessee, Arkansas, and Mississippi. We've done some cases out of, I've worked on some cases out of Georgia, Texas, North Carolina, and some other areas. So what just to let you know what my perspective is coming into a discussion of this type of employment discrimination, it comes from being someone who's litigated cases. Now I'm the director of the office, which puts me in more of a bureaucrat job. And so I am with the government and I'm here to help. So people always laugh when I say that. They don't believe me. Can my employer take religion into account in making employment decisions? Hopefully we'll know a little more about that after we finish today than we know now. So, okay. These are the laws that are enforced by the EEOC. Title VII of the Civil Rights Act of 1964, the Equal Pay Act of 1963, which requires males and females to be paid equitably. The Age Discrimination Employment Act of 67, which prohibits discrimination against individuals who are 40 years of age or older. The Rehabilitation Act of 73, which prohibits discrimination against disabled individuals in the federal sector. The Genetic Information Non-Discrimination Act, which deals with employers not being able to use genetic information about employees in making employment decisions. And the Americans with Disabilities Act of 2008, which prohibits discrimination against individuals based on disability. And the Lilly Ledbetter Fair Pay Act of 2009, which also deals with pay equity in terms of gender. Now, what I'm going to focus in on today is Title VII of the Civil Rights Act of 1964 as amended. It prohibits discrimination in employment based on the following: race, sex including pregnancy, national origin, color, religion, and all of these sections also have a non-retaliation provision. In other words, you cannot retaliate against an employee or an applicant because they assert their rights under Title VII. Title VII for coverage requires that an employer have 15 or more employees in the current or preceding calendar year. Now there's a couple of sections that I think are particularly relevant to discussion about religious discrimination. Section 703, it is unlawful for covered entities to discriminate against an employee or applicant for employment because of religion. Section 701J, the term religion includes all aspects of religious observance, practice, and belief, unless an employer shows that it cannot reasonably accommodate the employer's practice without undue hardship on the conduct of the business. We're going to talk a little bit more about what that means. Now, Title VII is an old law. As Title VII was going through Congress, there was initially a draft that came out of the House of Representatives that had a specific amendment that said atheists would not be covered under the religious protection. When that version of Title VII got to the Senate removed that amendment on constitutional grounds. So there have been various amendments over the years to Title VII, but from fairly early, we have statutory support for religious discrimination cases. Okay. I don't want to spend a lot of time on charge statistics on a Saturday morning, but the EEOC nationwide, we're going with fiscal year 2012. We don't have fiscal year 2013 yet. We were shut down there for a few weeks. You may have heard about that. But we're back and glad to be back. But anyway, looking at fiscal year 2012, there were a total of 99,417 charges of discrimination filed under all the statutes. Of that number, 3,811 alleged some form of religious discrimination. Now, the Commission, during our administrative process, found a violation on 300 religion charges in fiscal year 2012. Now, during the administrative process, this is before we have circumstances where if we find a violation, we can also file suit in federal court. In cases that we were able to resolve during the administrative process, we collected $9.9 million on the resolution of religious charges in fiscal year 2012. Okay. Who's covered? What are the exemptions? We're going to spend a little time on this. It's generally the same for all Title VII bases. In other words, the same for race, sex, and religion. You have to have an employer with 15 or more employees. It also involves employment agencies and unions. Now, there are some big exceptions, and we're going to spend a little time talking about religious organizations in a minute. But just kind of the thumbnail on that, religious organizations may in some circumstances give employment preferences to persons who share the same religious beliefs. And then secondly, the ministerial exception. A recent case out of the U.S. Supreme Court from last year, Hosanna Tabor Evangelical Lutheran Church and School. Somehow I lost Lutheran in there, but it's a Lutheran church and school versus the EEOC. Now, I want to talk about that case for just a moment. What that involved was an individual who was a school teacher and taught at the school. Now, there were two types of teachers at this facility. There were what they referred to as lay teachers and called teachers, C-A-L-L-E-D. A lay teacher did not have to be a member of a Lutheran congregation, did not have to have embraced the Lutheran religion. A called teacher, or in some parts of the decisions referred to as an ordained preacher, had additional training and had embraced the religion. Now, what happens is this teacher teaches kindergarten and fourth grade, teaches math, I think language skills, but in addition teaches religion classes and leads prayers with the children. Everything cooks along fine, and then she comes down with narcolepsy and needs a reasonable accommodation, not of her religious beliefs, but needs a reasonable accommodation under the Americans with Disabilities Act. She is unable to get that from her employer. She files a charge of discrimination with the EEOC under the Americans with Disabilities Act, saying she needs a reasonable accommodation based on her physical disability, the narcolepsy. She also says she was retaliated against for asserting her rights. Well, it's unable to be resolved during the charge process. Then it goes forward, and the EEOC finds a violation of the law and files suit in U.S. District Court. Initially, what the defendant, Hosanna Tabor, did is assert the ministerial exception, saying essentially that she's a minister and that both for purposes of Title VII and purposes of a First Amendment claim, she wouldn't be covered by these statutes. The first level court, the district court, the trial court, granted summary judgment to the employer, said, we agree with you, she meets these criteria to be a minister, therefore she can't assert this Americans with Disabilities Act claim. It is appealed to the next level, to the circuit court level, to the Sixth Circuit Court of Appeals. The Sixth Circuit Court of Appeals said, no, she's not a minister. Ministerial exception applies to members of clergy and people that are very close to being clergy in terms of what their duties are. They said this person is not a member of clergy, her duties are not sufficiently close to being clergy, she is a school teacher. Well, there are a lot of cases floating around in the different circuit courts around the country, which leads the case to make it to the U.S. Supreme Court. And the U.S. Supreme Court sides with the employer and applies the ministerial exception and focuses in on a few elements, the key elements being that she conducted religious classes, that she led prayer services, and that she went through an ordaining ceremony. So she represented to the Lutheran Church that she was a minister by doing that. And secondly, that she claimed an exception on her tax forms. She represented to the IRS she was a minister. So what you put on your tax forms? It may, little did you know, 10 years after you file your tax return, you'll be talking to the Supreme Court about something you put on your tax form. So long story short, this has been what I've seen, and we can't talk about specific charges that are pending. If a charge doesn't make it into litigation, we can't discuss it because of the confidentiality provisions of Title VII. But there have been a flood of assertions now post Hosanna Tabor, when you get a religion discrimination charge, that, oh, this person's a minister. And there's a whole spectrum of how that comes in. Some people clearly are ministers, and then some people are not. Not everybody that works at a school or works at a religious organization necessarily would qualify. Okay, what's a religious organization? Religious organizations, one with a purpose and character, is primarily religious. Factors are whether it's affiliated with or supported by a church, whether it's articles of incorporation, state a religious purpose, whether its day-to-day operations are religious, are the services it performs, the product it produces, the educational curriculum it provides directed towards propagation of the religion, and whether it's nonprofit. Again, that takes us back to what's been represented to the IRS. The guidance also defines religion. Sincere and meaningful belief that occupies in the life of its possessor a place parallel to that filled by God. Religion includes not only traditional organized religion, but also moral or ethical beliefs as to what is right and wrong, which are sincerely held with the strength of traditional religious views. Religion typically refers to ultimate ideas about life, purpose, and death, including right and wrong. Taking that a bit further, religion includes not only the beliefs of established and organized faiths such as Christianity, Judaism, Islam, Hinduism, and Buddhism, but also religious beliefs that are new, uncommon, not part of a formal church or sect, only subscribed to by a small number of people, or that seem illogical or unreasonable to others. For example, religion includes idiosyncratic beliefs that are theistic in nature, non-theistic moral or ethical belief systems, atheism, agnosticism, or any absence of religious beliefs. There's been a lot of litigation over the years about what is a religion and what is not a religion. We had a case out of Northwest Arkansas a few years ago that a colleague of mine brought that involved an individual who was essentially a religion of one. And as you got into litigation, the employer wanted to do the type of litigation the type of discovery. We wanted to depose other people that practice your religion. We wanted to depose the ministers. We wanted to depose other people that would know about it. Well, it doesn't work if you're a religion of one. So it can be a wide range of things. Okay, now with that said, let's talk about how religious discrimination comes into play. It could be in the range of disparate treatment. It could be discrimination based on recruiting, hiring and promotion, discipline and discharge, compensation and other terms, conditions, or privileges of employment. And there's a lot of subsets that go under that, but that's kind of the big ticket items. Now, let me give you an example of a case we had out of White County, Arkansas, a few years ago. We had an individual who applied for a job as a truck driver. And when he's initially interviewed, the gentleman that interviews him says, "No problem, looks good, come on down, your experience is great, come on along. By the way, do you have any problems working on the weekends?" And he said, "No." He said, "But probably need to tell you I'm a pagan minister." And he had cards that described his profession as a pagan minister. Well, again, this man's offered the job. He's given a cell phone so they can call him and track him as he's driving the trucks around. It's these guys that are driving trucks for the oil and gas work that's being done in that part of the state. Well, it gets up the food chain. First level supervisor's okay with this guy based on his experience. It gets to the owner of the company. And he's like, "Well, how's this guy looking?" "Oh, he looks fine. By the way, interesting thing. He's a minister." The guy says, "Oh, okay. He's a pagan minister." "Oh, wait a minute." Shortly thereafter, he's not qualified. it's not going to work out, and he loses his job. So you can have this come all throughout the process. It can be something that happens in the hiring process. It can be things that happen after you have been hired. It can include a lot of different aspects of your employment. Another thing we see frequently in employment cases is segregation of assignments, or even sometimes physically segregating an employee in where you have them in the workplace. Title VII prohibits workplace or job segregation based on religion, including religious garb and grooming practices, such as assigning an employee to a non-customer contact position because of actual or feared customer preference. A lot of the early cases we saw in Title VII dealt with customer preference. You're seeing this still in religion cases and in other aspects, but some of the earlier cases dealt similar to the Heart of Atlanta case, where white customers didn't want to be waited on by black individuals working in restaurants. And the employer would say, well, it's not me, it's my customers. My customers are the unreasonable ones, and I need to be able to keep my business going, so I have to cooperate with the bigotry of my customers. And that's not a great defense. It wasn't a great defense in 1972, and it's not any better now. We saw a lot of this, and we put some guidance out on this post 9/11. Individuals who there were a lot of discrimination involving Sikhs, involving Muslims, individuals who wore headgear, that they wore items that outwardly advertised their religious beliefs, and that employers were adjusting their work assignments to limit public contact. Okay. Religious harassment. This is very similar. The analysis is the same for religious harassment as it is for racial harassment or sexual harassment. Unlawful religious harassment occurs when employees are subjected to unwelcome pressure or coercion to abandon, alter, or adopt a religious practice as a condition of employment. Unwelcome harassing conduct that is based on religion and is so severe or pervasive that an individual being harassed reasonably finds the work environment to be hostile or abusive. Now, we're going to talk about hostility in terms of a hostile environment a little more in a few minutes. But think about severe or pervasive. Some acts of discrimination in the workplace are so severe that they only have to happen one time for you to have an actionable claim. Now, we've seen that a lot of times in sexual harassment cases. I've had cases where the individual was literally assaulted. You don't have to be assaulted 3 or 4 times to be covered by the statute. One time can do it. We've had situations involving racist threats of violence. You don't have to get a half a dozen of those. It can be, the event itself can be so severe that one event can get you to an actionable claim. Now, if it's not at that level, if it's more in the nature of conduct like emails, comments, things that are not quite as egregious, think about it being pervasive. If it's a one-time comment, or you're frequently going to see courts say, well, they used the N-word a couple of times here, but it's a stray comment, so that's not enough. But if it's something that's said frequently, if it's said over and over again, if it's said after the person has indicated their displeasure, after they've used the company's policy to try to stop it, if it continues to happen, even though it might not be severe as the attack, it's pervasive enough to where you can assert an actionable claim. So just keep in mind kind of that balance as we go through. Coercion. It involves a supervisor or manager, and examples are mandatory workplace prayer meeting or service. There are a number of cases out there about workplace devotional meetings, and we're going to talk about one here in a minute. Require answering phones with a religious greeting, and arguably the other side of that, prohibiting answering the phone with a religious greeting. That we've seen both ends of that. And required church attendance. And related to that, require that an employee not attend church or be religious. Let me give you an example of required church attendance. We had a sales manager who had a sales staff of about 5 people. He taught Sunday school. Nobody was coming to his class. He wanted to get his attendance up. So he encouraged all of his employees to come to his class. The person who filed a charge with us, will refer to that person as charging party. Charging party said, no thank you, politely and respectfully to her boss, no thank you, I've got plans Sunday, but thanks for asking. The other 4 went to the class, again and again, every week. Well, what happens? Is that in and of itself discriminatory conduct? Is there an adverse action attached to charging party for not going? Well, let's take this a little further. What happens after they go a couple of times is, after Sunday school they go to church, after church they go to lunch. And lunch at the local club, they start talking about sales leads. And so there's a finite number of sales leads. There are some sales leads that are plum leads. And what we're able to see over time is the people that go to Sunday school get the plum sales leads. Charging party who doesn't go gets the dregs. She gets what's left. So you can have a situation that started off just fairly innocuous invitation to being able to attach financial harm to it. I mean, literally this individual is making less money because they are not going to the Sunday school class. Okay. Hostile work environment, it's based on, for purposes of religious discrimination, it has to be based on religion, unwelcome and severe or pervasive. For example, written or verbal comments, jokes, slurs, name-calling, or physical mistreatment or threats of physical mistreatment based on religion, whether or not religion is mentioned, disparaging a person's religious beliefs or lack thereof, or proselytizing to a coworker who has objected to being proselytized to. Okay. One of the things that you're going to see frequently in the discussion of religious discrimination cases is the concept of reasonable accommodation. Now, employers are required to reasonably accommodate an employee's religious beliefs or practices unless doing so would cause more than a minimal burden on the operations of the employer's business. And it's frequently referred to as whether or not it'll cause an undue hardship. What does that mean? It depends on which judge you get. I've done a number of religion cases over the years, and some judges have looked at it as a very de minimis inconvenience, and some you've had to attach more substantive detriment to it. Let me give you an example. This is a case that the EEOC brought a number of years ago. It's EEOC versus Tanley Engineering, and for people that like to look up cases, I went ahead and put the citation in there. It's out of the Ninth Circuit. In this case, let me give you just a little bit of background on it. The employee's name is Mr. Pelvis, P-E-L-V-A-S, and he goes to work for the employer in 1979. All's well. In 1982, the employer added to their employee handbook, all employees are required to attend the non-denominational services each Tuesday. Initially, it's not a problem for Mr. Pelvis because even though that's gone into the employee handbook, there's multiple locations. The location where he's working, they haven't started doing the devotional session yet. In 1984, they start doing the devotional. And Mr. Pelvis asked to be excused because he's an atheist. He says, goes to supervisor, says, I don't want to go to this. I'm an atheist. I'm not interested in this. I don't want to go. He is told that failure to attend is equal to not attending work. And his supervisor says, look, you can go, you can read the paper, you can sleep, just go. Okay? And Mr. Pelvis says, no, I'm not going. And he went to the United States Equal Employment Opportunity Commission and filed a charge of discrimination. Now, this matter works its way through the courts and ends up in front of the Ninth Circuit Court of Appeals. And the Ninth Circuit upheld the lower court's ruling that required that the employer accommodate Mr. Pelvis's objections to devotional services and his request for the reasonable accommodation of being allowed not to attend. And they have a quote that I put in that I think it's kind of a long opinion, but I think it summarizes the Ninth Circuit's position on this case. Protecting an employee's right to be free from forced observance of religion of the religion of his employer is at the heart of Title VII's prohibition against religious discrimination. They also issue an injunction dealing with the mandatory nature of attendance at these devotional sessions. They say you can have a devotional if you want to, but you can't mandate that individuals go. Before I get off of that, I was working a number of years ago on a case involving a warehouse facility, and it was not a religion case. It was another type of Title VII case, and we were about to wrap up the matter that we had pending, and the company's attorney said, "Can I talk to you about another matter?" And I said, "Sure. What you got?" He said, "Well, this employer has a chaplain on staff." And I'm like, "Okay." And he said, "And they have a weekly devotional service." And I said, "Well, tell me about that." And he said, "Well, on Sunday mornings, they have an hour-long devotional service from 9 a.m. to 10 a.m. I said, "Okay, what else you want to tell me?" He said, "Well, your choices are you can go to the devotional service for an hour and be paid for that hour, or you can continue to stay in the warehouse and do your work and be paid for the hour." And he said, I've got a problem with that. And I said, "Well, I understand." I said, "Have they considered any other options? Have they considered, allowing the other individuals to do something else during that hour? If they're not," because he said they're not going to consider not doing the devotional. I said, "Okay." And we discussed some other things. And what eventually happened in that situation is the employer continued to do their devotional, but they also opened up another section where if you did not want to go to the devotional, you could take a nap, you could eat your breakfast, you could read your paper, read a book, play your video game, do whatever you wanted. And so in that situation, remove the potential adverse action. And there wasn't any indication from what we saw that there were necessarily any goodies attached to going, unlike the sales manager example I gave you. Okay, now I want to talk a little bit about retaliation. All of the laws enforced by EEOC have an anti-retaliation provision. And I've done a lot of training over the years on retaliation, and I can tell you some of the best cases we've ever brought are retaliation cases. We frequently have had a sex discrimination case, a race discrimination case that was an okay case, but the employer made it a great case. We used to do a section to say, don't turn a lukewarm, sexual harassment case into a red-hot retaliation case. And we've seen a lot of that over the years. So it's important for us to let employers know that they have to allow employees to assert their complaints without fear of retaliation, and to let employees know that protection is there. It's unlawful for an employer to retaliate against an individual for opposing employment practices that discriminate based on religion, or for filing an EEOC charge, testifying, or participating in any way in an investigation, proceeding, or litigation under Title VII. What to do if you believe you've been subjected to discrimination. Somehow we lost discrimination there. I'm sorry about that. Just imagine it says discrimination. Take advantage of the company's internal complaint process if it exists. An employer can't solve the problem unless it's aware of the problem. Most employers want to be made aware of discriminatory practices, especially harassment, so they can correct it and prevent others from becoming victims. A couple things about this. There's a couple of really good reasons why you need to do this if you have a problem in your workplace. One, there's a real chance that they may fix the problem. What I've seen over the years, over and over again, first line supervisor gets in his or her brain that this is a great thing for them to do. Upper management or corporate management out of state somewhere doesn't think this is a good thing for them to do. They don't necessarily want their lower level supervisors engaging in any type of discrimination because of the costs involved, because of the potential liability. And they're really not hiring supervisors, in most cases, to promote their particular religious beliefs. They're hiring them to do work. So I wouldn't hesitate to use the company's policy for that reason, to give them a real chance to try to resolve it. The second reason is, if you don't, fairly commonly, frequently, you're building in an affirmative defense for the employer. Supreme Court said back in 98 and 99, especially in harassment situations, you need to use the policy and give the employer the opportunity to correct the discrimination. If you don't do so without a really good reason, the employer may have an affirmative defense to assert. So there's a couple of good reasons to do it there. If we have any employers in here, I encourage people to put their complaint in writing, but if they're not willing to, don't ignore the complaint. You need to act on the complaint either way. I encourage individuals to put their complaint in writing for a couple of reasons, and especially now with the wonders of email. If you put it in writing and then email it to your boss, if you email it to Human Resources, if you email it to Human Resources in headquarters and say, here's what's going on with me, I've had enough of this, I've been subjected to this conduct, I need some help here. It's really hard for them later, if you file a charge, to pop up and say, well, if only they told me, we could have done something. You've created an electronic paper trail there. The second part is, as you go through the charge process, if you get in a situation where a matter is litigated, unlike what you see on The Good Wife, where bad things happen on Monday, you meet with the lawyer on Tuesday, you have an action-packed trial on Thursday, and then they do a breakdown of who's upset about the trial on Friday. That's not how it works. If you're going to litigate a case, you're going to be deposed, you're going to be put under oath and questioned about it, not the next day, about a year and a half later. We've had cases where it's been 5 years later. And it's real easy when a lawyer asks you, hey, what happened back, in 2008, for you to go, But I think it's helpful for you to put it in writing, let the employer know what's going on, and you've dealt with it when it's fresh on your mind, when witnesses are fresh on your mind, when the information is there. And if this is a coworker, I would encourage you to talk to the supervisor or talk to HR, similar to what I said before, and see if this can't be headed off. Now, how does someone file a charge with the EEOC? If you've gone through this process, if you've tried to fix it, if it's continuing, if you believe you've been a victim of employment discrimination, you can contact the EEOC. The fact you contact our people for information, one of our investigators, one of our attorneys, if you've talked to our people for information, that's confidential. If you actually use the charge process, if you file a charge of discrimination with the EEOC, we're required by statute to serve it on the employer within 10 days and ask them for their response. But the fact you want to get more information, we're not going to tell anybody about that unless you actually file a charge. Again, I've mentioned retaliation about 10 times. This is the 11th time. Employers are prohibited by law from retaliating against you for filing a charge. Now, the deadlines on this are pretty tight, especially if you're in Arkansas or Mississippi or Alabama. In Arkansas, since we do not have a Fair Employment Practice Agency, you must file your charge of discrimination within 180 days of the discriminatory conduct. That's pretty tight. So keep that in mind. If you live in a state with a Fair Employment Practice Agency, for instance, Tennessee, Missouri, Texas, Louisiana, surrounding states, you would have 300 days to do it. And I could do about 2 hours on what's messed up about that. But I know you've got other folks coming. What are the potential damages and other relief for Title VII violations? If someone has been denied a promotion, if you have somebody like the individual I talked about who wasn't getting the sales lead and if adversely affected their income, or if you're terminated, If you prevail in a Title VII claim, you may be entitled to back pay, reinstatement if you were separated from your job. If they can't put you in the job, if you didn't get the promotion to district manager and they put somebody else in district manager, the law doesn't require that they pull that person out. So they may have to pay you front pay until they can find you a comparable position. You may be entitled to non-pecuniary compensatory damages. That's what we see in terms of emotional distress, pain and suffering, that type of thing. Pecuniary compensatory damages, if you have to relocate to another, if you lose your job based on your religion, if you have to relocate to another city, those may be some costs that you can recover. If you incur medical expenses that would have been covered by your insurance, and you've lost your insurance because you were dismissed, those are some of the types of out-of-pocket expenses, job search expenses, things like that. Punitive damages, again, we could do a couple of hours on what you got to do to get punitive damages these days, but it's a possibility in a Title VII setting, but generally you have to prove discrimination plus. You have to show it's more than just you establishing the underlying claim. Injunctive relief, very important. It's something that the EEOC is very concerned with. When we file suit against an employer, when we litigate a case, we're not only trying to get relief for that particular individual, we're trying to stop this conduct from happening in the future. We're very concerned about prospective relief. So frequently we require, either through settlement or through litigation, that an employer conduct training, that they let their staff know that they shouldn't be engaged in inappropriate conduct. We frequently do monitoring. We've had them change policies. There's a lot of things of an injunctive nature that are there. And the Townley engineering case I talked about, the Ninth Circuit case, there's injunctive relief in that case. Essentially the district court entered an injunction saying you can no longer force people to go to these devotional services. Fees and costs. Attorney's fees in an employment discrimination case can be huge. So that's a big deal. If you're a prevailing party under Title VII, you're entitled to fees. Frequently, it's generally up to the district court what those fees are going to be. If you enter into a settlement, sometimes that can be negotiated. And costs can be substantial as well. Okay. How do you contact the EEOC? I'm giving you our 800 number, our TTY number. These numbers are staffed. This is a great way to get in touch with us. We have a contractor that we can talk to people in 151 languages. I wasn't sure there was 151 languages, but anyway, there's also an email process to start that allows you to get information and to start the charge process. I would encourage you, if this is a topic you're interested in, we have a lengthy guidance on religious discrimination that's on our website. It's eeoc.gov. It's regularly updated. There's also stories about cases that we filed over the years dealing with religion and dealing with the other statutes, the other bases of discrimination. And we have 53 locations around the country. We're part of the Memphis district, so we have an office here in Little Rock, 8th and Louisiana. We have an office in Midtown Memphis, and we also have an office in Nashville, Tennessee. That's our district. But we're spread out around the country. Now, I've been asked to leave some time for questions, so I'm going to leave some time for questions. Anybody have a question? Yes.
My question is quite simple. If I'm asked to testify in a case regarding anything, what do you advise someone of atheism to say or do when we're asked to tell the whole truth, nothing but the truth, so help me God?
It's if you're in a deposition or if you're in a court proceeding, is that what you're talking about?
Yes.
Before I went to work for the EEOC, I worked for the federal courts in the Western District of Arkansas. I would just if you're in court, you can advise the court that you ask for the alternative oath, and you can swear or affirm without invoking God. And it's not uncommon. I've seen that both in depositions and in courtroom proceedings. But if you're in a deposition, I probably would go ahead and advise counsel before you get started just let them know. But if you're in a courtroom proceeding, you can advise the court, and they'll take care of it.
There's an alternative.
There is, yes.
What is that?
It basically says you agree to tell the truth under penalty of perjury. And in fact, there's a federal statute that we use frequently for affidavits that cites the statutory language that says, I affirm that the following is true under penalty of perjury. So I mean, you're agreeing that it's true, and that you're advised that there may be criminal sanctions if you're given information that's not true. But it's become fairly common, so I wouldn't anticipate a problem. Yes. Who'd I have? I had somebody. Yes, sir.
So I had a question about the sales manager. The sales manager case that you were talking about. Since the meeting took place after the church service, wouldn't it have been easy for them just to say, you don't have to come and attend the church service, but we're going to have a sales meeting afterwards, and then there wouldn't have been a problem?
Oh, absolutely.
Okay.
But I mean, I don't think it was accidental. I mean, I think he purposely. I think there's a lot. Right, there's a variety of things he could have done other than what he did, and I think that would be fine if he said, we have some sales issues. We need to get together on Sunday and talk about it, and let's all meet at the club at 1 and discuss it. I don't think that would be an issue, but the charging party's allegation was specifically that the goodies were attached to going to the Sunday school class.
The problem that I have with this case is that I could see it. An identical case that has nothing to do with religion and church. For example, if I have a board game group, and some of the people from work come to my board game group, and we end up talking about work, those are the people that I most closely align with. There's always going to be something special out of that. So.
In this, you see a lot of the older cases where it's the golf club cases.
Yeah.
It's women can't play golf. And take it back, African Americans can play golf or take it further back, people who were Jewish couldn't play golf because of limits at the golf club. And so if you were a white male and could go play golf, you were more likely to get the goodies than the folks that couldn't go. But I think if it's more like that, if it's, we were talking about Borg last time, if it's, we all got together to watch the new Star Trek movie, and whoever went out, we started talking about some good sales ideas, and that all worked out. You can't tie it to one of the discriminatory bases that we have. So if somebody came in wanting to assert a charge on those bases, we'd say we don't have jurisdiction because it doesn't hit on race, sex, religion, national origin, those things. But yeah, and frequently we have situations where it's just flat out favoritism. You just like somebody. You go, they're your lunch buddy, or you like riding motorcycles together, or you're both like backpacking or whatever, and it's not tied to one of these illegitimate bases. So that would not be the type of conduct that would be covered by Title VII. That's a great question. Yes, ma'am.
One more question.
I'd like to ask about atheists and politicians. And politicians are compensated. Is that a job? I understand in the state of Arkansas, you cannot become elected official if you're an atheist. Has this been challenged anywhere in any state where an atheist was elected and then removed from a post because he was an atheist? Do you consider, I consider this pretty important, church and state, because one of the ways to really fight this and get good laws is to have atheists in the legislatures. So gay people and feminists and but okay, if that's my question.
Okay.
Okay.
I'm not. Thank you. I'm not aware of anybody I'm not aware of anybody that was running for office, or that was an office holder that they wouldn't swear in or wouldn't seat because of them being an atheist or because of any other belief. And I'm not aware of anybody being expelled from a legislative seat or any other political seat because of that. But that's an interesting question. Okay, we have somebody coming from the back. Come on up.
We don't have any more time. We're eating into our break time, and
all right.
So we're going to have to move along.
I don't want to mess the break up. Don't let me be the guy that messed the break up. But.
Let's give Bill Cash a round of applause, everyone.